What kind of record can hold 439 dead men, a colliery that had exploded before, a safety deadline missed after extensions, and a penalty remembered as 24 pounds? Senghenydd asked that question from the last page first. The remembered version is not legally exact. Edward Shaw, the agent and manager, was fined 24 pounds. The company side was fined 10 pounds with costs. The correction does not soften the case. It makes it more precise. Because the law had already begun dividing responsibility into pieces. One piece for a manager, one piece for a company, one piece for an offense the court could name. Around those pieces sat the fact the penalties could not hold. 439 men and boys were dead. The inquest returned accidental death. That is where an official record can begin closing a case. But Senghenydd did not leave only a verdict. It left a trail of warnings, duties, breaches, delays, and penalties small enough to become part of the evidence. The inquiry carried three institutional voices: R.A.S. Redmayne, the chief inspector, Evan Williams for the coal owners, and Robert Smillie, president of the Miners' Federation of Great Britain. The report counted the dead by number, occupation, and cause. The Valley counted differently. Centenary reporting later put the family scale at 542 fatherless children and more than 200 widows. The official number was 439. In the Valley, that number became missing wages, fatherless homes, and names that waited decades before a public memorial gathered them in one place. The case begins at the end, because the end is where the scale becomes hardest to explain. 24 pounds for Shaw, 10 pounds plus costs on the company side. Not for 439 deaths as a single legal charge, not as a clean exchange of lives for money. The law was more exact than that. It charged what it could name. It fined what it could divide. That precision is why the ending is so disturbing. Universal Colliery stood in the Aber Valley in South Wales. On Tuesday, October 14, 1913, it was a working industrial system. Coal was being cut. Men were moving through roads and districts. Air was being drawn through workings that depended on inspection, lamps, signaling, and control. The colliery was known to give off large quantities of inflammable gas. After the explosion, the gas emission was measured at about 1,200 cubic feet per minute. The danger was not invisible. Shaw was not a distant name placed on the file afterward. The record places him inside the management structure as agent and manager. The inquiry knew where to locate him. It also knew the mine depended on routines that sounded orderly when written down. Before men began work, firemen were supposed to examine the places. That rule has a clean surface. It makes danger sound visible before labor reaches it. At Senghenydd, distance weakened the rule. Firemen descended before the shift, but they had limited time to travel from the lamp station to distant workings and inspect them properly. Redmayne concluded that some inspection rules were likely being breached. A safety rule that depends on time and distance can exist on paper while failing underground. That is one of the first separations in the case. The rule as written and the rule as lived inside a deep, working colliery. The first warning had come 12 years earlier. In 1901, the same colliery suffered a major explosion. That earlier record had already learned the language that mattered again in 1913: coal dust, the spread of flame, and the need for better watering or dust control. Senghenydd was not a mind meeting the danger for the first time. The file already knew that coal dust could enlarge an explosion. It already knew that watering and dust control belonged to safety, not tidiness. Coal dust changes scale. A gas ignition may begin in one place. Dust can carry flame outward, through roads and workings that were not part of the first spark. That was not a theory invented after the disaster to make it look preventable. It was already inside the colliery's own history. Then the warning became legal. The Coal Mines Act of 1911 required work that would allow the air current to be reversed. In plain terms, the mine needed a way to reverse the direction of air in an emergency. That could matter to smoke, poisonous gases, and the movement of air through the workings. The deadline had been extended. More time had been given, then more time again. By October 14, 1913, the work at Universal Colliery was still incomplete. Counsel admitted the contravention. This was not a rumor from below. It was not a warning lost because nobody wrote it down. It was written into law, delayed by extension, and still unmet when the morning shift went underground. Hansard later recorded that proceedings had been instituted for contraventions. The parliamentary record did not have to create the breach. It was already there. The warning was not missing. It was late. A safety system not completed by deadline is also a financial document. That does not prove a private motive. The record does not allow that, but it does show the shape of the decision. Production continued while required safety work waited. The cost could have been paid before the disaster in work, interruption, and compliance. Afterward, it was priced differently. There were warnings closer to the day itself. On August 18, 1913, less than 2 months before the blast, the workman's inspection record used the colliery's own plain vocabulary. It noted diluted blowers. It noted roads wanting cleaning or watering. It noted roads that were very dusty. These were not prophecies. They were entries. A man reading that record did not need to imagine the future to understand the problem. Gas was being observed. Dust was being recorded. Watering or cleaning was being asked for in ordinary safety language. Then men were still expected to enter those roads. This is one of the quietest forms of danger in an industrial record. A condition becomes visible, but not urgent. A dusty road becomes a line in a book. A required action becomes something that can wait. The inquiry also did not need to imagine danger from electricity. Universal Colliery used electrical signaling equipment. The equipment could spark when bells were rung. A circular issued after the Bedwas explosion in 1912 had already called the attention of South Wales owners to electric bell sparks. That warning existed before Senghenydd. The lamp record added another weakness. Cambrian safety lamps at the colliery were fitted with unapproved glass. Lamp lockers lacked the written authority required by the Act. A safety lamp is supposed to be a controlled object in gassy workings. Its construction, custody, and authority belong to the boundary between flame and fire damp. Fire damp means methane-rich gas found underground in coal workings. At Senghenydd, large volumes of inflammable gas were known. Add coal dust. Add signaling apparatus capable of sparks. Add inspection routines strained by distance. Add lamps and lamp lockers that did not meet the legal standard. Add reversible air current work left incomplete after an extended deadline. The danger was not one thing, it was a stack of weaknesses. Redmayne later regretted that the safer plan of excluding sparks altogether had not been adopted. That sentence is not proof that a particular electrical spark caused the explosion. It is narrower, and it is enough. The safer policy would have been to remove the spark hazard. The record does not need certainty about the first instant to show that several barriers were weak. By the time the morning shift was underground, the later inquiry would be able to separate the ingredients: gas, dust, signaling gear, strained examination, questionable lamp controls, unfinished ventilation work, a prior explosion, a recent inspection entry, a legal deadline that had passed. But the exact origin of the explosion was never fixed. Redmayne's report did not claim certainty here. It treated Mefking as the probable point of origin, with gas released by falls and then ignited either by signaling sparks or by rock sparks. The inquiry treated this as probability, not proof. That distinction matters. The inquiry could not prove the first spark, but it could prove the conditions around it. The likely sequence began with fire damp near Mafeking. Gas was probably released by falls. Some ignition followed. The possible sources named by Redmayne were signaling sparks or rock sparks. From that first ignition, coal dust became the larger danger. The 1901 explosion had already shown why dust mattered. In 1913, the same problem returned in a colliery still producing, still gassy, still relying on roads where dust and watering had already been written into inspection records. A pocket of gas can begin an event. Dust can give it reach. The inquiry's reconstruction was not the simple story of one careless act. It was a chain of conditions: gas, ignition, dust, ventilation, inspection, equipment, and delay. That is why uncertainty about the first spark does not erase the warnings. Electrical sparks or rock sparks lead back to the same field of known hazards. The case does not become clean because the first instant remained uncertain. It becomes more troubling because so much around that instant was already known. The explosion moved through Universal Colliery on October 14, 1913. It traveled from the workings into the wider system of the mine. Roads that had carried men and air now carried force, smoke, and afterdamp. Machinery was damaged. Air routes were disrupted. The ordinary geography of the colliery became harder to read. Afterdamp is the poisonous gas left after an underground explosion. In many colliery disasters, it is as deadly as the blast itself. The number that entered the public record was 439 men and boys killed. That number belongs beside every earlier entry: the 1901 explosion, the August inspection, the unfinished reversible air current work, the spark warning, the lamps, the dust, the legal breach. Taken alone, the number is overwhelming. In the file, it is also evidence of how far the failure traveled. Rescue work followed, but the report cannot make the underground minutes whole. No one can narrate the inside of Senghenydd minute by minute. Many of the men who could have explained the first moments died in the places the inquiry later had to read, from damage, air conditions, and surviving evidence. The honest account is narrower. Men were trapped in smoke and poisoned air. Routes that had been ordinary working passages became damaged, confused, or unusable. Rescue parties faced the colliery not as it had been in the morning, but as an altered system of gas, dust, wreckage, and uncertainty. One rescuer, William John, age 31, died on October 16th during recovery work. His death matters because it shows the disaster was not finished when the explosion passed. Recovery entered the same damaged system. The mine remained dangerous. The air remained suspect. The work of reaching the dead carried its own risk. Then came the second failure, not the blast itself, the translation of the blast into procedure. Hansard recorded that, under the rescue apparatus rules then in force, a colliery could rely on a rescue station within 10 miles. That does not mean no rescue work was attempted. It means the system allowed preparedness to be placed at a distance. In a disaster measured by air, smoke, and minutes, distance is not a small detail. Water supply also entered the parliamentary record. Hansard shows the question still open in May 1914. The government stated that water supply was not then dealt with in the act or regulations and would be considered. The colliery had already exploded. The dead had already been counted. The August inspection had already noted roads wanting watering. Months later, Parliament was still being asked whether the law dealt with water supply at all. The system could investigate. It could prosecute. It could consider. It could defer. The valley had no such distance. Centenary reporting later put the family scale at 542 fatherless children and more than 200 widows. Those figures do not need embellishment. They are the social shape of the death toll. Families lived with the aftermath immediately. Public memory moved more slowly. The colliery continued to work until 1928. The National Library of Wales records that no memorial for the victims was unveiled until 1981. That gap matters. The file existed. The penalties existed. The official findings existed. But a public memorial naming the dead did not stand in the valley for decades. Law can close a case long before a community has any public forum large enough to hold what happened. The official language after Senghenydd was restrained but damaging. The inquest returned accidental death. Proceedings were instituted for contraventions. Redmayne wrote that several breaches together showed disquieting laxity in the management of the colliery. That phrase is careful enough for an official report and severe enough to survive it. Disquieting laxity does not say one man caused everything. It says the management system had loosened in places where looseness mattered. Inspection, lamps, signaling, statutory work, dust, and the conditions under which gas and ignition risk were allowed to coexist. The inquiry did not have to choose between accident and fault. It could call the deaths accidental and still record contraventions. It could acknowledge uncertainty about ignition and still identify failures around the event. That is what makes the small finds so difficult to place. They did not appear after a blank record. They appeared after an inquiry that could name prior danger, incomplete work, doubtful inspection, questionable lamps, electrical spark risk, dusty roads, and statutory breaches. The law had words for some of those things. It had offenses, it had proceedings, it had penalties. But the penalties were small enough to become the question rather than the answer. The simplified story says Senghenydd is easy to understand. A terrible explosion, followed by a derisory fine. The record is more precise and more disturbing. The ignition was uncertain. Redmayne treated Mafeking as probable, not proven. The source may have been signaling sparks or rock sparks. The hazards were not uncertain in the same way. The danger of electric bell sparks had been raised before. Coal dust had already appeared in the colliery's earlier disaster record. The reversible air current work required by law had not been completed by extended deadlines. The August inspection record had already written down gas and dust concerns. The lamps and lamp lockers showed breaches of control. And the fine was not simply one owner paying £24 for 439 deaths. Shaw, as agent and manager, was fined £24. The company side was fined £10 with costs. The correction matters. It prevents a false version of the law from replacing the real one. But the real one is not reassuring. The record divided responsibility into offenses it could prosecute. It attached penalties to named breaches. It priced fragments of a larger failure. That precision can look like fairness. It can also make the scale of the disaster seem legally unrecognizable. My read is that the smallness of the fine is not a side note. It is the final scale of a system that could describe risk in detail but punish it only in fragments. Consider what the file already held: the prior explosion, the dust danger, the unfinished ventilation work, the strained inspections, the gas, the sparks, the lamp breaches, the August warnings, the dead. It knew enough to be uncomfortable. Yet the legal ending was small. £24 for Shaw, £10 in costs on the company side, accidental death at the inquest, contraventions in the proceedings, questions still open in Parliament. There was no immediate memorial of the scale the Valley needed. The file remained. Later the plaques came. Each name corrected what the legal record had made small, not by changing the evidence, but by refusing to let the dead remain only a total. The pit worked until 1928. The memorial did not arrive until 1981. Between those dates, the disaster lived in records and in families before it was gathered into public form. I would not call that closure. The open question at Senghenydd is not whether gas and coal dust can destroy a colliery. The record answers that. It is not whether warnings existed. The record answers that too. A prior explosion had warned the colliery. An inspection entry had warned it. A circular about sparks had warned South Wales owners. A statute had warned management through a deadline, then through extensions, then through breach. After the disaster, the same system could investigate. It could prosecute. It could fine. It could consider new rules. It could preserve the evidence. But preservation is not the same as protection. If a warning can be written, extended, breached, prosecuted, and priced, at what point does the record stop being a safeguard and become only a receipt?